Hello there, my name is Mutiaba Conrad. I'm a lawyer and a private law tutor and also a practicing advocate of the High Court. In this video, we are basically going to be looking at institution of criminal proceedings, but more specifically, we're going to be looking at the modes of commencement of criminal prosecutions. We will look at the law that provides for those modes, and we'll also discuss those modes a little bit more in detail. But before we commence with our class, I encourage you to ensure that you subscribe to my channel. Just click down on the subscription button. Also turn on your notifications so that every time videos are released, you don't miss out anything. And then finally, students interested in private law tutorial sessions, please feel free to reach out to us. Our numbers are down in the description box. Contact us and we'll be able to make private arrangements with you and we'll be able to help you. So let's jump straight into our topic today. We are going to be looking at the modes of commencement of criminal prosecutions. But before we go into those modes, let us just give our discussion a background. Now, at what stage are we here in the criminal prosecution process? The stage we are on is the first stage. We are at the stage where criminal prosecutions are being commenced. This is the beginning stage of the process, the whole process of criminal prosecution. So we want now to look at the various modes of how criminal prosecution is commenced. Now, it's important to know always that these various processes or these various modes of commencing a criminal prosecution are provided for under the law. And I encourage you to interest yourself in looking at section 42 of the Magistrate Courts Act. It clearly stipulates and lays down the various three modes of commencement of criminal prosecutions. But then it's also important to note that these modes have further been fortified in quite a number of judicial decisions. But for purposes of this class, we're going to be looking at the decision or at the case of Uganda versus Longino. It's a case of 1975 High Court Bullet, page 306. This case laid down these modes, and as I also earlier stated, you can further find them under section 42 of the Magistrate Courts Act. This is the Magistrate Courts Act of the Republic of Uganda. For most of my viewers watching from Kenya, watching from Zambia, Tanzania, South Africa, and Nigeria, if you look down in your statute books, specifically under the Magistrate Courts Act, you'll be able to find these various modes of commencing criminal prosecution. So let's look at them a little bit more in detail. So the first mode of commencing criminal prosecutions is what we call by a police officer. So this is the normal way, okay? If you are a complainant, you walk into a police station and you register a complaint. So the police officer brings a person arrested before a magistrate upon the charge. So you walk into a police station, you register a complaint, the complaint is written down by a police officer, and then of course the file is later on sent to the state prosecutor, and then at a later stage you are presented to court for purposes of criminal prosecution. So that's the first mode. The first mode is by a police officer bringing a person arrested before a magistrate upon a charge. So a charge has to be formally brought against the person, and then you're presented before court or before a magistrate for purposes of answering those charges. So that's the first mode. Let's now proceed to look at the second mode of commencing criminal prosecution. The second mode is by a public prosecutor, okay, or a state attorney, or even a police officer, for that matter, laying a charge against a person before a magistrate and requesting the issue of a warrant or summon. So it's important to note that state prosecutors can also commence criminal proceedings. And how do they do this? They do it by laying a charge. They will lay a charge against an accused person before a magistrate, and then they will request the magistrate or the judge that summons or a warrant of arrest be issued against that person. So this is very important to note. A state attorney, okay, or a state prosecutor can also commence criminal proceedings. This can actually be fortified by Article 120, Clause 3B of the Constitution. And if you read under that article, you will quickly realize that one of the powers that are given to the DPP or to these state prosecutors is what we call the power to institute criminal proceedings on any person, institution, or body. So the state prosecutors actually have that mandate. They can commence criminal proceedings. They emanate their powers from Article 120, Clause 3B of the Constitution. And it's important to note that they can charge either a person, an institution, or anybody, okay, for acts of a criminal nature. So that's the second mode of commencing criminal proceedings. Let's now look at the third and last mode of how criminal prosecutions or criminal proceedings can be commenced. This mode is by any person who has reason to believe that an offense has been committed. This person or that person can commence these criminal prosecutions. Of course, this is done formally by laying a charge. Actually, it starts by laying a complaint. So you walk to any court around you if you believe that an offense has been committed. You walk into any court, then you put in your formal complaint. Your formal complaint must be written. You address it before the magistrate or the judge of that court or that area, and then the judge will examine it, okay? And if in the wisdom of the judge, he discovers or he identifies that actually the facts or the complaint as stated to him reveals an offense or ingredients of an offense, then he will reduce that charge. He will reduce your complaint into writing. He will draft a charge, and then at a later stage or immediately, he can then proceed to even issue out summons or even a warrant. But it's important to note that the judge must satisfy himself or herself that indeed your complaint is not frivolous and it's not vexatious. What we mean here by frivolous and vexatious, these are simply legal terminologies to mean that the charge must not be, must have merit, okay? Meaning that the charge must have merit. The charge must not be based on bad motive, okay? It must not be intended to hunt out someone. So the charge must be grounded. It must have a merit in it, okay? It must not emanate from spite, okay? Or any bad motive. So the moment the judge identifies that the charge is not vexatious and it's not frivolous, then he'll proceed to reduce it into writing, and then he will ensure that a charge sheet is drafted, summons and a warrant is then sent out. But then also the law allows that you can also make this complaint orally, okay? You can also make it orally, but again, in case the complaint is made orally before a judge, that complaint, once again, must be reduced into writing. So, ladies and gentlemen, those are basically the three modes of commencing criminal prosecutions. So, in case you're asked of the various modes, those are the modes, and the law, as earlier discussed for you, I invite you to interest yourself and look at Section 42 of the Magistrate Courts Act, and then also Article 120, Clause 3B of the Constitution is very authoritative. So I would love to hear your comments about these various modes. So please comment down in the comment section. Give me your answers on what you think or what you actually thought were the various modes. And in case you have any other mode which in your view you think is valid, please share it with me down in the comment section. And in case I learn any other new mode from you, I promise I'll give you at least a free tutorial class of my choice. So I'll choose one person who probably has commented or given me any interesting or new answer. Of course, if it's correct, then that person will win themselves a free tutorial class. So comment down in the section, and then I'll be waiting to hear from you. So we meet again in another class. And once again, students interested in private law tutorial sessions, please feel free to contact us. Our numbers are down in the description box. Just text us, you can email us, or you can call us directly, and then we'll be able to help you. Please remember that these private law tutorial sessions really work, and students that are on our private law tutorial sessions have been continuously proven to outperform their colleagues who do not have any sort of mentorship. See you again in another class. Bye-bye.